For Creamer Media's Polity, I'm Sane Dhlamini. Researcher and analyst Professor Raymond Suttner joins me to discuss the need to transform the legal profession. Welcome, Professor.
Thank you very much.
You say that you aren't going into the question of the barriers in the way of representativity that starts long before the Judicial Services Commission process. What are these?
Yes, in the article, I had a particular focus, and that focus related to what happened in the Judicial Services Commission. But long before you reach the process where you may be selected as a judge, the inequalities of South African society make it less likely that black people, especially Africans and especially women, will even reach that stage of being considered as a judge. This is because of the poverty. Some people don't go to school. Some girls are not allowed to go to school because of what some people see as customs in their villages. When they get to school, the schools are more likely to be inferior in quality. We know a lot of schools have not even got toilets, not got desks, not got textbooks, etc., etc. So it's very, very difficult to get to the point where you pass through school with the grades which will ensure that you get to university. When you get to university, because of the inequalities of this society, the white students are more likely to have access to textbooks, to internet in their home. They're more likely to have no problem with electricity. They're more likely to have a computer in the home. In the legal profession, textbooks are much more expensive than in English literature. I Googled, just by chance, Googled law of contracts, and a book came up which was in its 4th edition, which means it must be quite popular, published in 2012. The cost was 600 rands. Now, if you're doing law of contracts, that's just one topic you're doing. So how difficult or how easy is it for a black person, especially an African person, to have the resources to have their own textbooks? Now, if you don't have your own textbooks, you go to the university, and I think they have what's called overnight books. And some books that are in big demand, like these, you have to put your name on the list. Maybe you can't get it when you need it. So you work under stress and under difficulty, which is very different from the average white student. Now, when I taught a master's course at Wits in politics, the students were in at least their 5th year at university. And many of the conditions, you could see looking at the class, the conditions under which some people worked. Some people would arrive late because the conditions for their transport to the university had elements of uncertainty. They had to take more than one taxi, and with a taxi, you can't always predict exactly when you're going to arrive. Sometimes you are there early, but they will not go till the taxi is full. And this is not a problem that crosses the minds of some of the students who were in that class. Some of the students in that class had iPads. Some had laptops. And I'm not saying no Africans had access to this, but in general, the condition under which people came to class, the conditions when they left the class, do they have a special room where they can work in their home without disturbance, these sorts of things. Now, let's say you do the LLB and you go to the bar. At the bar, or let's say if you want to be an attorney, you have to be accepted for articles at a firm. Now, these firms, the well-established firms, are more likely to admit people who are part of the networks of their friends and associates. Someone who's a son or daughter of some person who's another attorney or a well-known advocate is much more likely to make it than Joe Modisane from Pimville or from Tsolo or from Bushbuck Ridge. And I should have mentioned, even before this stage, if you're not studying at WITS or UCT, if you're studying through UNISA and you're in the rural areas and you've got to submit your assignments through the internet, you actually got to register through the internet. And usually you have to go to Mthatha or one of these study centers to do it. It's a very costly journey. And when you get there, the internet may be down. Okay, that's before we reach now. I'm saying when you want to be qualified as a lawyer, it's not enough to have a LLB. You actually have to do articles. If you're an attorney or if you're an advocate, you've got to do pupillage. In both of these cases, there is a stringent selection process. And in the case of attorneys, it is more likely that you will get in easily if you come from a family or a network. People are in networks that are well known. They belong to the same clubs, they play golf together, their children are at the same school and all of this. Now, the directors of leading firms will not play golf with the sons or daughters of someone from Bushbuck Ridge. Those parents will not be in Johannesburg in any case. If you want to be an advocate, they have what's called pupillage. Now, I'm qualified as an advocate, but they didn't have pupillage then. You just could get admitted. But if you want to do pupillage now, they have something like 200 people who've applied this year, from whom they choose about 100. And what happens to the other 100? It means they've got an LLB, they can't get there. And it may well be that the command of English, in which the interview is more likely to be conducted, is much better for white advocates. So the bar at that level is limited. But then let's say you are qualified as an advocate. Now, all this time, you're earning very little. Now, I believe they do pay pupils a bit. But once you go to the bar, you've just got to sit there, wait to be briefed as an advocate to do a case. How do you support yourself? Now, these firms tend to brief people, again, who are well known to them, etc. And to get experience, it's useful if a senior advocate asks you to be what's called his or her junior in the case. Now, there are a whole lot of these factors that can make it more difficult for black people to advance in what is still a white male profession. The same things apply in varying degrees to women, but I'm going to go into that more fully when I write a new article this week. But I mean, what provision is made for women as child bearers and child rearers?
You say that the fact that one is black or a woman does not mean one's approach to the law is necessarily transformatory. What do you mean?
To be black is a physical quality. To be transformatory is to have ideas about changing things as they are. Now, very often when you get into a position, it's a victory for you and you are not concerned about making it a victory for all who have suffered disadvantages. Now, in the one case in the Judicial Services Commission last week, there was a woman, and I'm going to write about it this week, who asked to be transferred from Mthatha to Bisho to be closer to her parents and to her children, because she was the child rearer. Thandi Modise, who is a mother herself and is the chair of the National Council of Provinces, said, "You'll get no sympathy from me." So what I'm saying is, when you say that black people must be admitted, it doesn't mean that those black people will embrace the cause of all black people. The fact that you have to combat patriarchal notions to get onto the bench as a woman doesn't mean that every woman who is there becomes a feminist, because what Thandi Modise said there was what a patriarchal woman would say. So she had absorbed the masculinized conceptions of what it means to be a judge. And if this woman, if she had to cope with her children while working, this woman must cope with it. That's it. So that's what I mean.
That was Professor Raymond Suttner speaking to Creamer Media's Polity about transforming the legal profession.